let's stick with Maui for a second because there's actually a question from someone in the audience about it. I mean, if you do a compare, if you use the compare feature on your on your computer software and compare the Alito dissent in Maui to the opinion of the court in Sackett, they're substantially similar. And so there is this question about what does this all mean? What does the functional equivalence test mean going forward, especially in an era when the court maybe isn't as concerned about the principle of stare decisis as it has been in prior generations. So does anybody want to take a swing at that? What's the current state of the functional equivalence test?
I'll weigh in. I think what the next cases will be critical. If it's a 402 with facts that just seem as though somebody is trying to avoid Clean Water Act regulation, I think even this court might adhere to the functional equivalence test and go for it if the facts line up with that. And just to refresh everyone's memory, under the functional equivalence test, time and distance are the two most important factors. So basically, whatever pollutants you're adding have to make it to a larger water, traditionally navigable water, as I would call it, in relatively the same shape they went into whatever they went into in a relatively quick time. The time in Maui was like 87 to 110 days, and not too far away. I think if those same facts came up again, particularly if an intent was relevant in the Sackett case, getting caught unawares, if it was fairly obviously an intentional discharge that was doing a lot of damage to, say, the Pacific Ocean again, I think even this court might stick to County of Maui and apply the functional equivalence test as written. Like I said, I think the more interesting situation is the first time somebody is trying to use the functional equivalence test in the context of Section 404. And I predict lower courts will allow that. I predict some lower courts will not. But that might be the situation where the court either cabins County of Maui to Section 402 or decides that it was a route that they shouldn't have taken, and that's what worries me. So that could be an interesting future, and like I said, next cases may be critically important to what happens to County of Maui.
Damien, Brooks, either one of you want to take a swing at Maui post Sackett?
Well, if I could just say that I think that what made Maui County a close case was the fact that it was groundwater that was serving as the vehicle. And I think that if we're talking about sort of indirect discharges that occur on the surface level, I agree 100% that even the Sackett 2 court would still probably affirm EPA jurisdiction, in part because, as Justice Kavanaugh's concurrence in Maui County points out, this was already essentially conceded by Justice Scalia in his Rapanos plurality, saying that you can either view these, if they're not regulated waters, they're point sources, and it just seems like it's much more likely that if you're talking about surface pollutants, that the discharger knows or ought to know that something bad might happen, especially when in the 402 context, when you're talking oftentimes about hazardous pollutants as opposed to 404, where it's mainly land use activities and dirt and rocks and what have you.
Mm-hmm.
So I think that despite the similarities that I think you very justly point out, Jeff, between Justice Alito's dissent in County of Maui and his opinion in Sackett 2, I think that even with that, I think we'd still see by and large the court today sticking with more or less the scope of liability that County of Maui seems to suggest.